One element of design law that doesn't get as much attention as it should is the important distinction between design specifications and performance specifications. Of course, when we think about the output of a design professional, we speak in terms of drawings and specs, right? Of course, drawings are visual and they deal with things like quantities and how one thing will interface with other components of the work. And specifications tend to be text. It's something that is written down. It's not visual, it's in word form, and it deals with things like the quality and types of equipment and materials, and the conformance with codes and industry standards and similar requirements, and levels of finish. And when we think about drawings and specs, we almost never burrow down into the concept of these specifications and think about what they are and what they mean. And this can be very important because depending upon the kind of specification you have, there can either be a door opened or a door closed for contractors to make change order claims and a variety of other claims. And so let's talk about specifications for a moment, and let's talk about the distinction between a few important kinds. One is a design specification, and a design specification is one where the designer sets out in precise detail what's required of the contractor. There's essentially no deviations permitted. And some industry groups, I believe, use the term prescriptive specifications to identify this kind of a specification, but essentially the contractor has no license to go out there and to use any creativity or ingenuity. They need to go out and procure what has been specified and then submit it and get it approved and install it. That's very different than a performance specification, which is where the design professional doesn't say you need to go and procure this very specific kind of thing, contractor. Instead, it talks about a standard that the contractor has to meet. It talks about an outcome to be achieved, and it invites the contractor to employ its ingenuity to go out there and to source materials and equipment that will comply with this performance specification. Now, there's a number of other types of specifications that I won't get into very much. One common kind that's actually commonly discussed but rare to see in a real project is sometimes referred to as a product specification or a restrictive or a brand name specification, and that's where the design team would tell the contractor to go out and to buy some very specific piece of equipment that is identified, perhaps down to a model number. You almost never see that sort of thing because it can really open the owner up to claims for a variety of reasons I won't get into now. But if we focus on design specifications and performance specifications and why they're different and why it matters, it's because there are times when a warranty can be attached to a design specification. This is a warranty that would be made from the owner to the contractor, essentially that the owner impliedly warrants that the design is good enough. And this is sometimes called the Spearman Doctrine, and I want to caution people that it varies tremendously from state to state. It can vary whether it's a public project or a private project. And it certainly does not always apply. Even if you have a design specification, you're not always going to have a Spearman warranty. But the Spearman warranty is a doctrine. It springs from government contracting law. It sometimes has been interpreted to apply on private projects. And while this is a very serious oversimplification, the Spearman Doctrine essentially is that an owner impliedly warrants to the contractor that the plans and specifications provided are free from defects and sufficient for the intended purpose. And of course, if a contractor is given a design that they have to comply with, if they build it according to the design, there's a good argument that they, ought to be absolved from problems with the design. And if there is anything that ought to have been designed differently, then the owner should take it up with the designer. But when there is this Spearman warranty that is extended from the owner to the contractor, it opens the door for claims and for change orders. And typically when you have a design specification, which sets out in precise detail, permitting no deviations, it's prescriptive, this is what the contractor needs to procure and install, that is when you can get claims and you can get change orders to the owner. And the Spearman Doctrine comes from an old case. I believe it's a federal contracting case from 1918, and if memory serves, it had to do with specifications that were for building a dry dock and for moving a sewer. And the specifications were really detailed about what the contractor should do and expect when it was moving this sewer. And it turns out that some of the assumptions that were in that design specification was not accurate, and the contractor brought claims to the owner, and the owner was found to have essentially impliedly warranted to the contractor the adequacy of the design. And since the design was not adequate under that fact pattern, the owner found itself opened up to claims and to change orders. And so, what's the takeaway here? Words matter, and specifications are not just something that are dense and technical and at times boring to look at. They can really have important consequences depending upon what type they are. If they are a design specification, if they're very prescriptive, if they tie the contractor's hands, that can, in some cases, open the owner up to certain kinds of claims that they might not be open to if the specification was a performance specification and did not tie the contractor's hands, but rather invited them to go out and to try to achieve a certain standard by procuring and sourcing certain materials and equipment.